Hello landlords, we've gotten a lot of requests from you to do a step-by-step video on how to fill out an eviction petition. Today we're going to do that. Let's get started. So what I have in front of me is a copy of a generic petition that I downloaded from the state of Texas website on the Justice of the Peace Court. So every case in the state of Texas for eviction starts off in the court of the Justice of the Peace in the precinct associated with the rental. And so the state of Texas produces this generic form. A number of the justice courts use this, and if you go to the Justice of the Peace, you're going to find this exact form there that they use. Now, different counties do different things, and so I know that in Harris County, where I practice, Harris County has developed its own form, but essentially it's the same. And so whether you're using a county-specific form or this generic form that was produced by the state of Texas, I'm going to talk about the different parts of the form and what you can do to fill it out on your own. Right from the beginning, let's go ahead and start at the very top. So you'll see in what's referred to as the style of the case, we have some identifiers. The first is the case number. And when you filed your lawsuit in the particular precinct where your property is located, you're going to have to identify certain things and fill in some data based on that court. So the court clerks will, once you filed, assign a specific number based on the numbering system for that particular court. At the top, you'll see, generally speaking, a handwritten number. Some courts are techier than others, and they'll type it in or produce a document that has it typed in for you. But many still handwrite in the case number. The next spot here is the plaintiff, and that's the landlord or the property manager who is identified in the lease. You don't want to have conflicting information here. And this is sometimes how plaintiffs get off the rails. If the lease says that Joe landlord is the landlord, but you write in 123 property management, there could be an issue of standing and whether or not 123 property management actually has the right to even appear in court if they're not featured in the lease and cannot otherwise produce documentation to show why they have specifically 123 property management has a superior right to possession over whoever they're suing for eviction. Again, this could be a problem. So make sure that the proper plaintiff is identified in this section. That is a crucial piece of your eviction petition. Below that is the defendant. Now, generally speaking, you're going to have to name all of the tenants who signed the lease. This is extremely important. It's not a matter of you name the main one or you name the one that you regularly speak with. If 4 tenants signed that lease and all 4 tenants are still in possession, you have to list each of them and sue all 4 of them. If there are 2 who signed the lease and one of them left, well, you can get by with just suing the one person who remains in possession after you delivered your notice to vacate. But if you have multiple tenants who signed the lease and continue to remain in possession, you must list them and you must sue them each for possession in your eviction petition. Over on the right side, you'll see that there's a spot for the precinct number. As your county is broken up into multiple precincts, which precinct is the one where your rental property is located? Now, if you live in Harris County, and this is true in a number of other counties, the precincts are themselves divided. And so you actually have a choice between, in Harris County, precinct 1, place 1, or precinct 1, place 2. And you can decide which of the courts, either geographically or if you've had better luck with a certain judge in your precinct than you have maybe with the other judge, and you may just prefer that. Generally speaking, you're allowed to choose either of the 2 courts within the single precinct, but you cannot pick your precinct. If your property is located within the boundary of a particular precinct, that's where you have to file. If your precinct has more than one place, then you can choose between the places where you would like to file your lawsuit. And of course, you have to identify the county where the property is located. Next is the complaint. Now on this form, it has a specific spot where you can, again, list out all the named defendants and then identify the rental property. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. This next section is essentially the heart of the case. What are your grounds for your eviction? What is the basis that you are using in order to demand possession from your tenant? There are three options here, and my advice is always, if your tenant is guilty of all three of them, make sure that you list all three of them. Because if any one of them is denied by the court, but you've got a backup, then you can still recover possession from your tenant if you are entitled to it. Let's go over the three that are available here. The first is for unpaid rent. Notice that it does not include things like late fees, deposits, repair costs. It's just rent. And so if you have an occasion of unpaid rent, you can fill that amount in, and these facts can be used to prove up your case for possession. Additionally, you could choose the section marked Other Lease Violations. Be specific. If there are multiple lease violations, mention all of them. It doesn't help you to have spare violations in your pocket when you show up to trial. If you say, well, they violated provisions 3, 4, 5, and 6, but I only had time to list number 3, that doesn't help you. If you have evidence and you have a viable basis to demand possession, the best thing for you to do is to put it in your petition at the time of filing. Don't wait for the time of trial to raise these issues for the first time. It's simply not going to work out for you. And finally, holdover. Holdover happens when you have terminated the lease or when the lease is terminated on its own. Now, the tricky part with this is there's generally an additional notice that would likely be needed to be produced. In this case, for someone to be guilty of holdover, it is because they stayed beyond the actual termination of the lease. Many leases continue on a month-to-month basis until one or the other parties submits written notice that the lease has come to an end. And so if you are accusing your tenant of staying beyond that, you probably will need to demonstrate to the court that you properly delivered a notice of lease termination in advance and in accordance with the lease and state law. In the state of Texas, the minimum notice requirement for a notice of termination is 30 days. Your lease may require more. Make sure you know whether that's the case and make sure that you have actually delivered this notice to your tenant to properly terminate the lease. This is not the same as a notice to vacate, which we'll get to in a bit. But in order to prove that you in fact properly terminated your lease and now your tenant is guilty of holdover, make sure that you take with you a copy of that 30-day or more notice of termination that you delivered to your tenant. The notice to vacate is an extremely specific notice. It must be a demand for possession. You may also demand things like fees and rent and certain activity if the tenant is violating the lease in some non-rent way. You can make all these demands, but if it does not feature a demand for possession, and the simple way to demand possession is simply to tell the tenant to leave. By default, the law requires 3 days of notice. And so I would say don't push it, even if your lease says you could deliver it with 1 day or 2 days notice. The additional extra days are really not going to make that big of a difference. I would argue that you're better off giving a 3-day notice, just like the law says. Even though you might have the right to give fewer days, you're just better off so that in the event that the matter is contested, you're still on the right side of the law by giving the 3-day notice. Now, it also refers to the property code, and it's important that if you've never reviewed Chapter 24 of the Texas Property Code, that you do so. Again, if this is your first time, you're going to want to become familiar because delivery of the notice is also a key part of a valid notice to vacate. Now, today's video is not going to be a deep dive into the notice to vacate. I've done numerous other videos, which you'll find on this channel, about notice to vacate. But please understand that if you've never done one before, there are so many ways to get that notice wrong. You'll want to make sure you've reviewed the provisions in Chapter 24 of the Texas Property Code and watched at least a half dozen of the videos that I've made on this channel specifically on the notice to vacate. Now, this particular petition goes on to make sure that the damages that you are seeking are for rent. And so you're asked, does the plaintiff seek or does not seek a claim for unpaid rent? This is going to change the dynamics. If you can claim rent, 100% do it. Don't just bypass the ability to collect rent because you think your tenant will not pay. It's important always to make a claim for rent, specifically because this could end up affecting your tenant's appeal rights. If there's no claim for rent, they could potentially appeal at a $0 rate. But if you claim rent and you prove that rent remains unpaid, your tenant would likely be required to pay their rent into the court's registry month to month as an appeal would proceed. Without a claim for rent, you could go many more months without a single dollar, and the tenant would have no obligation to pay you directly outside of the obligation of the lease, which they have already breached. That's why you're in the eviction court. Don't hamstring yourself and waive rent when you're entitled to it. If unpaid rent is a factor, make sure you indicate that properly in your eviction petition. Now, this petition also includes a provision for attorney's fees and an immediate possession bond. If attorney fees are appropriate in this petition, well, that means you have an attorney and your attorney is filling out this petition. But if that attorney is anything like me, I've got my own petition. I don't use these generic default petitions. I like drafting my own and wording it the way I prefer. Your attorney probably would do the same. So if you do have an attorney, speak to them about their petition if you have questions about what they include and why they include those things. As for an immediate possession bond, I'm just not a big fan. They're available under the law, but I rarely see these things successfully deliver possession to a landlord any sooner than a regular eviction would. I'm not going to dive into the particulars of an immediate possession bond. I've also done videos on this topic. If you're interested, you can look for that on my channel. Just know I'm not a big fan. I don't think it's a great idea. Procedurally, it's kind of silly. Next, we go on to the citation itself. And this is important because the law requires that the tenant is served with proper notice, usually by a constable, sometimes from a private process server, but that they are delivered proper notice at least 6 days in advance of a trial setting. If you, for whatever reason, have not properly identified where the tenant can be served, and generally for an eviction, that's going to be the rent property, and for whatever reason the tenant is not served, well, the trial simply cannot proceed. Now, sometimes a constable will make multiple trips to the property that you are trying to recover possession of, and knock, 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 nobody answers the door. The tenant may be inside, maybe they're gone, who knows, but the constable is unable to serve proper notice to the defendant. When this happens, the court might have to employ alternative service. And for an eviction, a court may authorize the constable to tape the notice to the outside of the door. That's not something you can normally do, particularly with your notice to vacate. But the constable may be allowed by the court to tape the notice on the outside of the door and to mail the notice to the defendant, giving them proper service as of that date. So long as that's 6 days in advance of the trial setting, you should be able to proceed to trial and present your case. The tenant at that point would have been deemed served by the constable with proper notice of the eviction filing from the court. The relief that you seek has to be explicit, and they've essentially written it all out for you, stating what you are asking the court. You're looking to recover possession. You might be looking to recover unpaid rent, attorney fees, court costs, and interest. All of these things are stated here very clearly. Now, one thing that tends to be true about these facts is that they change over time. With every passing month, an additional sum of rent becomes owed, and if unpaid, is part of the calculation that can be figured out so long as your petition is drafted properly to indicate that rent was outstanding at the time and unpaid of the time of filing, and that additional rent becomes due every rent period that passes before the time of trial. And so it's important that these facts are stated clearly and that you recover from the court everything that you are entitled to. You've got to ask for it or you can't get it. That's the important part of this particular segment of the petition. Finally, there are two boxes here. One where you could request a jury to hear your case. This is something I have never recommended for a landlord. Juries can be quite complicated, and they will undoubtedly extend the amount of time that you spend prosecuting this case. 90% of these cases are heard in front of a judge, the first trial setting, and are resolved that same day. Typically, these cases don't usually last more than 5 to 10 minutes. So if you're asking for a jury, that process could take the entire day, maybe a half day, but it will take significantly longer. And the court may not be able to hear it on the first available bench trial setting where you would have been had you not elected a jury. They might have to set it sometime in the future, which could be weeks, sometimes months ahead. It's simply something that I just don't recommend. The final checkbox has to do with how you consent to receiving notice from the court and from the opposing party. If you consent to email notice, you can check this box, and all future notice is sent to you by the court, or if the defendant answers the lawsuit, they can serve you that answer, or their attorney can, at the email address you have disclosed. Finally, you're asked to submit information about the defendant, including, and this might seem weird at first, their date of birth, the last 3 of their driver's license, the last 3 of their social and their phone number. This information is important in the event that you seek to abstract the judgment later. So if you have this information, it's helpful to disclose it, because if you win a judgment for any amount of money and want to place this judgment on the credit history of the tenant, by abstracting this information together with these identifiers, you will be able to attach this judgment to this person specifically and then later seek collection. If you have questions about an abstract of judgment or any efforts to collect, again, various videos on this channel. Look around, you will find. You sign the petition, and the last thing you do is you swear to these facts in front of a notary or in front of the clerk of the court. Then it's signed and submitted, and the eviction process begins. If you have all of these things set up and you show up to the court with evidence, you can attach your evidence to your petition. Evidence might include photographs, it might include a copy of your rent ledger, it should include a copy of the notice to vacate that you delivered properly to that tenant, which they neglected and did not move out after having received it. And so all of these things can be submitted and attached to the petition, submitted as exhibits that you will present at trial. I hope this was helpful to those of you who have never filed an eviction petition in the past. If it turns out that you might need a little more assistance than just this video, naturally, you can come seek me out for any eviction that would be filed in any county across the state of Texas. I'm happy to help in any way. Naturally, my license doesn't extend beyond the state of Texas. And if you are in a different state, note that while some of the procedures might be similar, certainly there will be differences from state to state. Contact an attorney in your local jurisdiction to find out the particulars about filing in your jurisdiction. For everybody else, if you have enjoyed this video, I'm sure that you'll enjoy the next. And YouTube seems to think that this particular video is something you will enjoy. Thank you so much. And landlords, until next time, happy leasing.